Hello, my name is Tanya Kinney for constitutionofindia.net at CLPR. You may have noticed that issues around reservations have been in the news of late. This was triggered by an ongoing case at the Supreme Court, which challenges the constitutionality of the 103rd Amendment that introduced reservations for economically weaker sections of society. Now, the court will decide if reservations can be based solely on income. 74 years ago, our constitution framers faced similar questions. Who should get reservations? On 30th November 1948, the Indian Constituent Assembly debated Draft Article 10. This draft article allowed the state to reserve government jobs for any backward class of citizens who, in the opinion of the state, are not adequately represented in the services under the state. Many members of the assembly were surprised and confused about the term backward class. Did it mean scheduled castes and tribes, women, minorities? Who? One member, T.D. Krishnamachari, criticized the draft article and said that backward classes was a vague term. Drafting Committee Chairman B.R. Ambedkar defended the draft article by saying that the term was deliberately vague. He argued that the government of the day should be given the authority to decide who constitutes backward classes. The draft was then accepted by the Assembly and made it as Article 16 of the Constitution of India 1950. A year later, however, to the shock of the Government of India, the Supreme Court in two separate cases shot down the Madras government's reservation policies for scheduled castes, scheduled tribes, and other non-Brahmin communities. The Nehru government now realized that the lack of clarity around backward classes in the constitution could lead to such more instances of the Supreme Court striking down similar policies. The government then acted quickly to rectify the situation by introducing the First Amendment, which allowed the state to make any special provision for the advancement of any socially and educationally backward classes of citizens or for scheduled castes and scheduled tribes. Dr. Ambedkar, who was now the law minister in the Union government, U-turned from his earlier policy of keeping backward classes vague. He now declared in Parliament that backward classes are nothing else but a collection of certain castes. Notice that in this whole story, while there was vagueness and data clarity on what backward classes were, no one ever thought that it would mean just economically weak classes. This is how reservations in India have been implemented for socially and educationally marginalized groups. The Supreme Court will now decide if this must change. Our friends at the Supreme Court Observer are closely tracking the developments on the EWS case. Visit their website to read more. And then head on over to constitutionofindia.net to read, search, and explore more on India's constitutional origins.
We hope you liked our video. We'd love to hear what you'd like us to cover next. Comment under this video or write to us at cadindia@clpr.org.in.